What?
For some reason, I got kicked out of the meeting.
I just got in.
What is going on?
I clicked the posted Zoom meeting thing and show up here as Shutesbury host. I'm not Shutesbury host.
Yeah,
Yeah,
I don't
I
understand
just,
how
I
I don't
just
know what's going on.
got kicked out of the meeting. We were in the meeting.
host. Do you
Right,
host
and
in
I
the
said
meeting?
to enter, I had to get out of the meeting I was already in, and I did not show up on the earlier.
All right, I
I'm
gotta,
gonna get out.
okay, if you don't mean to be in it, go ahead.
Are you calling me?
Are you there, Carrie? Is that you, Carrie?
Yeah, I've been here. Yeah.
Oh, I didn't know it was you. Okay.
Yeah.
Okay, so what happened? Everybody else got kicked out?
Yeah, no, the whole meeting shut off. I don't know what happened. I have no idea what's going on.
Okay, let me message people.
And I don't know why there's still another Shutesbury post.
When I clicked on it, I got a message that said waiting for host to start. And then it said at the top, Conservation Commission scheduled for 10 p.m.
Yeah, don't worry
Yeah,
about it.
that's an issue with Zoom. Me and Grace have been trying to fix it. It's in the wrong time zone, my guess is, and we've been trying to fix it and we can't.
Oh,
get
I
it
gotta-
Anyway, I just kept the thing open
just-
and miraculously I came on.
Okay, I'm trying to call people because we don't have a quorum, so hang on here.
You're muted. You're muted. We can't hear you. I still can't hear you. You're muted.
The top of my screen says Shutesbury host is currently host. That's my name on this thing, but that's not me.
Okay. Do you normally host meetings at all?
I hosted a meeting earlier today.
So then you have to log out of that one and log into your personal one in order to enter the meeting without it coming up as Shutesbury host.
I log out of that meeting.
No, you log out of the current Zoom account that you're using, which is a Shutesbury host, which is why your name pops up as Shutesbury host. And if you have an alternative one that you use for your personal use, then you'll log into that.
But I clicked on the posted URL for the Zoom meeting.
I mean your Zoom account, the one that you use to sign in.
Okay, I'll go out and come back in. Thank you.
You're welcome. I guess I'll update the link again, because that's the only thing I can think to do. Oh,
Carrie,
yes.
Carrie,
Yes.
hello?
Can you hear me?
Yeah, I can now. Now, when you go to the Shutesbury calendar, it says Open Space Committee and the agenda is not there.
Okay.
I need you to go
we're
back.
gonna fix that.
I need you to fix that. When you do the link,
I'm posting the one that I'm currently using, so I don't know what happened. I opened it as normal. Okay. Okay. Okay, I think more people are signing in, so I think this is working.
Finally got back in.
Great. Hallelujah. All right. Do we have a quorum here? I'm going to call the meeting. I've got, is Beth
Happened
here?
to Scott.
I don't know where Scott is, but we need Beth because I am going to be recused after I open the meeting. So where's Beth? Could somebody call Beth? Let me see if she's. So you guys all got in because you clicked on the calendar link?
I went back to the calendar link just now, and the link that's up the very top of the page let me in. I in the numbers
Well,
my- but
so what I'm seeing is we've got Robin, we've got Mary, we've got me. We do not have Scott. And we do not have Beth. And we need at least one of them. There's Beth. Hallelujah.
Yay.
All right, and then we'll just keep going. All right. Beth, are you there?
Yes,
Okay.
Here.
Hallelujah. Could somebody please email or text
Scott.
Scott?
Just came in.
Okay, great. Okay, I'm going to convene the meeting of the Shutesbury Conservation Commission. Meeting is beginning at 7:13. We have Miriam DeFont, Mary David, Robin Harrington, Scott Kahn is here, and Beth Wilson. We're running late and we have several hearings. So in the interest of being efficient, what I'm going to suggest is that we go through these public meetings, close the public meetings, and then do our deliberations and finish up the permits later so that we don't run behind and make everybody wait while we do that. Is that all right with the commission?
Yep.
These are easy RDAs. I don't think it's going to take a long time. So I think we can do this very efficiently. So Beth, I'm going to hand over the reins to you for the first one.
Great. I'm opening the public hearing for 74 Pratt Corner Road, DeFont Kibler, driveway resurfacing and rain garden construction. And Miriam, you are the applicant, so can you please present your project?
I will be happy to. Because of all this kerfuffle, I don't have the site plan ready, but we have a bordering vegetated wetland and intermittent stream that goes under our driveway via a culvert. The driveway is gravel and there's a steep grade on the driveway, and we're having a lot of issues with erosion, as well as the driveway being very icy in the winter and unsafe. So we are proposing to add a good thick layer of trap rock on top of the existing gravel for the whole length of the driveway. We're not going to be excavating anything. We're not removing any material from the driveway itself. There's a turnaround near the BVW that is currently very compacted gravel that we use for our cars. And what we're proposing is to take a section of that turnaround and convert it over into a rain garden with native herbaceous plants in order to improve the stormwater management in that area. So there will be less gravel and runoff going into the wetland. And we think that this will overall enhance the environmental conditions on the property. We're not proposing any alterations to bank. So We don't believe there's any alteration to the BVW. And we'll be using erosion socks to protect the culvert area as well as the down gradient part of the rain garden during that construction.
Great, thank you. I guess the only thing I was wondering, who's doing the work and what is the schedule?
Clark is putting in the gravel and they're going to dig out the rain garden because it's too compacted to do it by hand, but the construction of the rain garden we're doing ourselves.
And is that's all this fall, is what you're
Yeah.
thinking?
We won't be able, because of their schedule, we won't be able to do the planting this fall, but everything will be stabilized and mulched and we'll keep the erosion controls up. And then this spring we'll put in the herbaceous plants.
Okay. That all sounds good to me. Does any other members of the commission have any questions?
No, it sounds good and it looked good at the site visit. Look a great plan.
Hi, this is
Um,
Jonathan
sorry.
Saruta. I'm just logging in for Bill. So
We
I
have
was
a-
told the meeting was at 7:30.
We're running late.
Oh,
Um,
okay.
And we're in the middle of another topic right now.
Oh, I'm sorry about that. Okay, so I'll log back in at 7:30.
Well, we're running late. You might want to stay on because we're going to try and move through things. But
Okay.
go ahead.
All right, if no members of the commission have any more questions, is there anyone from the public that has any questions about this application?
No, it looked good to me on the site visit.
I actually can't see if anybody's raising their hands.
No. No hands.
No hands. Okay. I think we're good then, because Miriam, you said we're not gonna go through the conditions or the actual permit right now.
Yeah.
We're gonna hold
We
off
just
on
need
that.
a motion to close the public meeting.
Motion to
have a mo-
close the public
Second?
meeting.
Second, anyone?
Second,
Okay, we're good.
You got to do a roll call, Beth.
Oh, yeah, roll call. Harrington,
aye.
David,
Aye.
Khan,
Aye.
And I
Wilson, aye.
And I suppose you should say I'm recused. Right.
Stefan is recused.
I'm abstaining, I guess, or I'm recused, whichever you want to call it. Not sure which is right.
Recused.
I am not voting. Okay.
And
I will
what does Beth vote?
Aye.
Okay.
Thank you, everybody. All right, moving on. Kestrel Land Trust made a request for a change to the order of conditions, and we're not going to have, we're not going to get into all of the details tonight. What I, and I understand that I see Chris Volantes here, and your contractor is here. And really the question before us tonight is whether or not the change is going to require an amended order of conditions, public hearing process. So what they are wanting to do is to change, they want to add to the bog boardwalk and the puncheon so that there would be some larger impacts, and they wanted a change to the mowing plan that's in the order of conditions. Do I have that right, Chris? So
Okay, thanks. I think the main thing with the boardwalk, its footprint is not being added to. We're changing the support structure type. And that change will require a different mode of installation rather than hand-driven piers. It will take some machine driving. We're proposing helical piles for that boardwalk now. And then the other change is relating to the boardwalk, the wooden puncheon style boardwalk in the wooded wetland, which was originally proposed to be repaired and extended by about 12 feet. We're now proposing to replace that boardwalk completely using diamond piers as the support structure, and we're proposing to extend its length by closer to, is it 30 feet
25.
Walker on each side? Yes,
Goes from 370 square feet to 450, so it's about 75.
right. The footprints of these changes are, if you look at the materials, are changing only marginally. One of the reasons for that is the wooded wetland boardwalk is going to be lengthened, but it's going to be narrowed. It's currently about 44 feet wide, and it's going to be 3 feet wide. And it's going in on the same footprint.
Well, what I would like to propose and is that we entertain making a determination tonight that this is a minor change and will require an amended order of conditions. Because this is changing the footprint and the methodology, and also you're wanting to change the condition around the mowing. And so we really have to change the order of conditions. And in order to do that, we have to have we have to have a public hearing. Sadly. But that would,
we do know the drill on that.
no, sorry about that.
We've done it before.
So,
Is there any chance of any fees being waived on this last go round?
well, the fees, there are no fees for an amended order of conditions. The fees are for the abutter notifications, which we can't waive, and legal notice, which we can't waive. So
Okay, I had a note in my notes that there was an additional fee last time, but that must be incorrect.
No, not for an amended order of conditions. So,
Okay.
Commissioners, could we, do you want to comment on that or discuss it?
No, I agree.
Yeah, I agree too. The changes are significant enough.
Okay, I'm sorry. So, would somebody like to make a motion to make a determination? This is a minor change and no new notice of intent is required.
I make a, oh, go ahead,
Go
Mary.
ahead, Deb.
Oh.
Go ahead, Deb.
I make a motion that this is considered a minor change, so no new notice of intent is required.
Second,
Second.
David,
Aye.
I, Harrington,
Aye.
Khan,
Aye.
Wilson. Okay, Wilson.
Aye.
Okay,
Can
so
you hear
thank
me?
you, Chris, and I'm happy to loop back with you about what we might need for that, and we can if you want, I can give you the date. We're meeting. I don't know if you can get this in all together for our next meeting, which is on September, or whatever that is, 20-somethings, 28th. Is that you'd have to get the abutter notifications and everything ready by next week. Do you
I
think?
think that would be tight. Might be better to push it to the next one.
Okay, so let's go to the 12th, and I will have to get back to you with the time,
Okay,
but we will do it on the 12th.
great.
All right, thank
All
you
right, thanks, everyone.
very much.
Thank you.
Well, all right, moving on, we have next on the agenda, we have an RDA. Let me see which one is it. Is it for the Lotto 32 is next?
Yes.
So we have a RDA for environmental investigations on Lotto 32 as part of the construction project. And I'm trying to find. So this involves they're doing some soil boring as well as some test pits in order to prepare for their design team. And the work is going to be in the buffer zone. Do commissioners feel like they need to see the site plan, or do you feel like you've already familiarized yourselves enough with the layout of where the work is going to be done?
Yeah, I think I'm okay with it. It sounds like it's something that needs to be done.
Yeah, I agree.
So one thing I want to note is that the applicants asked whether we would waive the fees. So we need to make a motion to waive the fees because this is a municipal project. Would somebody like to make that
I
motion?
make a motion to waive fees for the library project.
I'll second it.
Okay, David,
Aye.
I, Harrington,
I,
Khan,
Aye.
Wilson.
You do have a hand up.
Aye.
All right, so moved. Michael Hootstein, do you have a quick comment?
Yes, can you hear me?
Yes.
Yes, I've just looked at the layout and the map. It is so inaccurate. Does not accurately reflect what any of the drainage, where this is very contaminated property. There's all kinds of preferred contaminant pathways running through this area. It's not going to be permeable soil. I don't understand how I've just never seen such inaccurate information. And the map is designed so you can barely read it. So, I mean, I understand that you've been threatened through and through by the town and you're going to have to provide this, but I do want you to know that the fraud committed by town officials on Lot 032 is going to be a part of the basics of my civil rights complaint. So I protest what's going on. I urge you to ask for more information and really go out there and see what they're doing. They're pulling the wool over your eyes. Thank you so much.
So I just want to make a note that this project under the Wetlands Protection Act is considered to be an exempt activity. So the RDA being considered tonight is not being considered under the Wetlands Protection Act, only under the bylaw. And when we make any determination, it'll only be under, well, I guess it's a negative, there's a negative determination that will have to issue for under the Wetlands Protection Act because it's exempt. Yes, there's another comment.
Excuse me, Miriam, can the applicant present before you take public comments?
Sure. We really weren't, what I was going to say is I would, if you feel like you need to present, personally, I feel satisfied that I have enough information, A, because it's already exempt under the Wetlands Protection Act, and B, I think we understand that this is necessary and it's very basic environmental investigations for your design work. So
And I agree with that.
we're quite pressured on time tonight. So unless you really feel like you want to explain it to us, but I'm pretty good with it myself, and I would think the rest of the commission may agree with me.
mm-hmm. Yep.
Is there something you feel like we need to know, Penny?
No, I mean, it's very, as you know, from going through the work near the old radio tower, it's very similar work, and there is no long-term, it's only temporary impacts to the buffer zone. They're very minor, and they're necessary for the next step in designing the library. I'm
Yeah.
happy to go through it in detail, but it sounds like you're all familiar with the project.
Thank you. I feel satisfied. This is not the notice of intent for the library. The applicant doesn't need to have a fully engineered and surveyed project site plan for this. Really, what we needed to know is where the wetland boundaries are, and we've already approved an ORAD for the wetland boundaries for this site, so that's already been determined. So this doesn't feel very complicated to me. Mary Lou, I'm like to move on. If you have a comment.
Do we need to vote on this?
Well, there's somebody had their hand raised. I'll allow a comment as long as it's apropos to this current application. We're not here to talk about the library project or anything else involving this lot. We're only here to look at this investigation that's being proposed tonight. So do you have a comment?
Hi. Yes. Hi, my name is Mary Lou Kanka. My question is, Miriam, or to the commission as a whole first, thank you for the work you're doing. I very much appreciate it. And second, my question is, where can, as a person of the public, find that exemption, what you just said? that this project is exempt. I'm a little confused by that. So maybe I could look it up. Thank
could-
you.
Yes,
I can clarify that. It is,
but Penny,
course-
Penny, please,
I'm asking the commission. Thank you.
thank you. Penny, raise your hand, please, if you want to say something. So the application, which is on the website, they quote the exemption and the citation for it, but you can go online to the Wetlands Protection Act regulations. You can Google CM 310 CMR 10.00, and in the first section, it has a list of minor exempt activities, and I believe it's G is environmental investigations that are of a temporary nature. So the reference is in the application, which is on our website, and I really don't want to go any further than that. I think that's enough for reference.
Thank you.
Okay. Do commissioners, do you have enough information to close?
Yeah.
Okay. And are there any other public comments? No. All right.
so will you vote on your determination now? I know you're not going to do the orders now, the determination.
We're going to do it at the end of the meeting because we're started so late. We had technical problems. And so we,
I understand that, but typically you vote on the commission's outcome of this while the public is here. I understand you're going to do the determination later.
we're going to deliberate and make the determinations at the end of the meeting tonight.
I'd like to request that you deliberate now while the public is here.
While commissioners, is that we've got other hearings and meetings scheduled. So I don't want to have to get into working on the permit right now. I have a draft prepared.
Yeah, I understand that, but I'm asking you to make the determination now, not prepare the orders now.
Commissioners, do you want to give the applicants some guidance? I am inclined to approve this under the bylaw as with conditions, our standard conditions for RDAs of this sort. And I have a draft prepared. The determination of applicability under the Wetlands Protection Act would be a negative because it's exempt. So we would be issuing two determinations, one under the Wetlands Protection Act and one under the bylaw. But I really would prefer to not have to open up the documents right this minute because we have another applicant who's waiting.
I understand that, but can the commission vote now?
Is that enough? Well, I think we would need to have the very specific language. So that means we have to open up the documents for the motions.
I mean, I'm comfortable with it, but I guess maybe I'm a little more familiar with the forms and what you just said. But I'm comfortable with, closing the public hearing and voting on the decision without having the documents open.
Well, I'll tell you what, I can probably open them up and
I don't think we really need to do it. I agree with Beth, I don't think we need to open the documents. I think we just need to close the hearing and do our quick vote.
okay, well, I've got the documents opening up right this sec. So if somebody wants to make a motion to close the public meeting. we can.
Motion to close the public meeting on lot 032.
Second,
Second,
David,
I.
DeFont,
David.
Harrington,
I,
Han,
Aye.
and Wilson.
aye.
Okay. So I've got the documents up. I don't have the, I do not have the, oh, this is a weird thing. This document is damaged. Ugh. Well, that's annoying. It's only one page. No, it's not. All right.
Do you want to do that part later, Miriam?
Well, the document's damaged, so that is a problem, but let's, so first, under the Wetlands Protection Act, I do have that document up, so I'm going to screen share it if you don't mind. so we can have that discussion. So this is the determination of applicability. There would be no conditions because it's exempt. So what I have filled out here is down here, a little lower, negative determination. The work is described. I have a 3 checked off. Because it's in the buffer zone. And then I have a 5 checked off saying the area is exempt. And no NOI is required. And I have the quotation for the public that was wondering. Here's the citation for CMR 10.02 2B 2G. So that would be the negative determination, number 3 and number 5, unless you feel like we don't need the 3. But I thought that it is in a buffer zone project, but I guess we could take it out because we're making a number 5.
Yeah.
So it's a -5. There's no conditions. Is there a motion to issue a -5 under the Wetlands Protection Act?
Motion to issue the determination with a -5 for the Wetlands Protection Act.
Second,
Second,
David,
aye.
Stefan, I, Harrington,
I,
and Wilson.
Aye.
Sorry.
And I.
So this document, I'm having a little, oh, I see what the problem is. Give me 1 sec. Okay. Text is all disappeared on me. So under the bylaw, I am proposing what is a negative determination number 3 with conditions. I have special conditions. The form is a little damaged. I'm gonna have to fix that, but I do have the special conditions up and I can show them to you very quickly. Let me screen share them. Okay, I think these are the right ones. Okay, here we go. Everybody see?
Yep.
So
Yep.
These are our standard conditions, but I did. Oh no, this is the wrong one. This is from last year. Sorry. Give me a sec. Here we go. Okay. Okay, everybody see it?
Yep.
Yep.
Okay. So findings, this is being issued under the bylaw, not under the Wetlands Protection Act, so I changed the wording. This is just a description of the project. I'm finding 4 is that this is exempt under the Wetlands Protection Act. 4 and 5, we're issuing this determination based on this site plan. And then all of the special conditions are our general stock boilerplate, nothing special, erosion controls, be the limit of work, and then that they would give us photographs of the erosion controls once they're in place in lieu of a pre-construction site visit, and then give us some photographs 30 days after the completion of the project. That sound good? Any comments?
Nope.
Looks good.
Looks
Okay.
good.
All right, somebody want to propose a motion then?
I make a motion to issue the order of conditions for lot 032.
Determination of applicability. Not an order of conditions, sorry.
Oh, right, sorry, determination of applicability with the special conditions for lot 032.
Second,
I
Dave?
second,
aye.
Stefan, I, Harrington,
I,
Khan.
Aye.
Wilson.
Aye.
Thank you very much. Thank you, Penny. And
Thank
Mary.
you, Miriam. I appreciate you getting to this step.
Okay. All right. So we next have an RDA for 27 Weatherwood Road. And this is Paul Littman. And hi, Paul. And is your consultant with you?
Yes,
Hi, welcome.
Aye.
Okay, so we're gonna open this as an RDA for a septic. Are you calling this a septic repair or a septic replace?
Septic repair.
Septic repair, including a new leach field and tank for a property on 27 Weatherwood Road, where they recently were able to get this property delineated, and there is an isolated wetland that is jurisdictional under the Shutesbury Wetlands Protection Bylaw, but it is not jurisdictional under the Wetlands Protection Act. And we have the delineation report from Ward Smith with his delineations. So I'm just calling attention to that. So the commission would have to agree to accept that delineation and that jurisdiction for this. Do you want to just take a few minutes and explain what you're doing and what the project is?
You want me to explain it? Basically, what we're doing is replacing the septic system. The existing system would not pass Title V. We have an area, we got to be 100 feet from the well. We're replacing the new tank. We're putting a new 1,500 gallon tank in, getting rid of the existing 1,000 because it's no longer acceptable in Massachusetts. And we're putting in a new leach field as close to the driveway, as close to the well as we can. I didn't know there was an isolated wetlands in there, but we can do whatever you want to. We could use a straw wattle or a silt fence. We're not even going into the woods. We're just going into the edge of the woods. So this is basically the area where the flower garden is. We're taking out his flower garden.
Yeah.
That's the whole project.
Yeah, usually our recommendation would be to use a straw wattle or a erosion sock with straw or some other mulch, but no hay.
Okay.
And for that to remain in place until the area is completely stabilized. Now, you know, it's going to be a little late in the season if you're doing the work soon. You're doing it like very soon, right?
Very soon. Like as soon as we get approval to do it.
So there isn't going to be a lot of time for grass to reseed.
Well, with the weather that we're having, the grass should go really, really quickly. So I'm anticipating we'll have grass before October.
So I think what we would want is to make sure that because you're going to have a large disturbed area, that it's really properly mulched and then keep it mulched until it's the grass is taken hold.
Yeah, we'll mulch it with straw.
So if by the time fall hits, and if it hasn't, you know, we would want you to keep the erosion controls in place and keep the straw on the surface until the spring. And it might require reseeding because sometimes, you know, seed all works great and sometimes it doesn't. If we get a hurricane and it just, you know, washes the seed away, then
we got one coming.
So that would be kind of what we would look for in something like this.
Okay, yeah, we'd take care of that. That's not a problem.
Right.
We'll put the straw wattle up and we'll mulch with straw. We'll heavily seed it. And normally in this type of weather, 4 days we get the seed sprouting. I mean, we got a lot of moisture. Usually we don't have this type of moisture in September. It's usually pretty dry. But in this particular case, a lot of moisture in the ground.
Okay. All right. Are there any more questions from the commission?
Just had one question. What's the closest point of excavation to the wetland line?
I'm not sure. I didn't see the delineation, but it has to be quite a ways away.
Okay.
We're basically
about
the existing system is just to the left of us, so we couldn't go there anyways. So
yeah, that was one of the questions I had too, but all right.
We could go measure it. I mean, that's the only way I could measure towards flagging.
Well, I don't think you want to have us not issue this permit. It sounds like you're really under some time pressure, so I don't want to delay.
Okay,
I don't feel like,
I tell you what, I could put it on the as-built plans.
I can say, that'd be great. I can say that from the site visit, it looked to be about 50 feet.
Okay,
So I'm pretty satisfied. It's at least, it's around 50 feet, which is fine.
Yeah. Yeah, no, I was just wondering, is it 10 feet? Is it, but 50, that's good.
Well,
yeah,
it,
we'll locate the wards flagging on the plan.
it wouldn't be a Title V compliant system if it was that close to the wetland.
Yeah. No, it should be fine. The existing system is right next to us, so
Okay. So,
and we're not removing any trees. No trees, no tree removal.
okay. Are there any public comments? Okay, somebody want to make a motion to close the public meeting?
Make a motion to close the public meeting for 27 Weatherwood Road.
Okay, is there a second?
I second.
David,
Aye.
aye. Harrington,
I,
Aye.
doesn't.
Hi.
Okay, I think we could do the deliberation for this. Because we're been really getting through this. So again, I would propose that we would do a negative determination under the Wetlands Protection Act because there's no jurisdictional area. So the form actually, let me just pull it up. So the form, just so I get it straight in my head, which number it would need to be for a negative determination where there's no jurisdiction is, it's a -1, which is that it's not subject to jurisdiction under the act. So that would be the first vote. Somebody want to propose?
I make a motion that we make a determination, a negative determination, one, that the project is exempt from the Wetlands Protection Act.
Second,
I second.
David? David? Oh, you're muted.
Aye. Sorry.
Aye. Harrington,
I,
Khan.
Aye.
Present.
Aye.
Okay, so here, under the bylaw, this would be proposing a negative determination number 3 with conditions, which is our standard thing. I've filled out all of these findings. The one thing we want to have a finding that this is exempt under, there's no, well, I did say that isolated wetlands are not protected under the state law. And under conditions, do we want to make sure that we've got conditions for late fall? Let's look at that. Well, it says maintain and repair erosion controls until the site is stabilized. We could say and revegetated.
Yeah, I think what's there is fine.
Okay. Is there anything else we want to add to ensure? And then here I have grass seeding within the auras only permitted. Do we want to require conservation mix? I don't really feel like it's necessary because it's it's already pretty landscaped area to begin with.
That's fine.
Grass is okay.
Okay, so the applicant should submit photos. What am I doing here? So we don't need number 15 at all. And just photographs of the site when it's completed and also photographs of the erosion controls. Whoops, pushed the wrong button. Does that look all right to everybody?
Yep.
Yep.
Okay, so somebody want to make a motion for a negative determination number 3 with conditions under the bylaw for this project?
I'll make a motion to issue a negative determination 3 under the Shutesbury bylaw.
Second,
Second,
David,
aye.
I, Harrington,
I,
Khan,
Aye.
yes. All right.
Aye.
Wow, we got through some stuff. And we're a little bit ahead of schedule, which is great, but we'll take care of some other things. So, we have a bunch of site visits that we need to take care of. And we have a few site visits that we've had recently. So let's just go over the site visits that we had recently. And I'm thinking I have here 135 Montague Road, but didn't we already review that at the last meeting? I can't remember when we went. I have it on the agenda for some reason. That was a septic system where we didn't find any resource areas. And then we did the site visit for 27 Weatherwood Road. We've already discussed it. I did a site visit and nobody could come with me because Mary was sick at the last minute for 11 North Laurel Drive. And this is an applicant who lives down by the lake and has a shed she wants to demolish that's about 20 feet from the bank of the lake. So I advised her that currently we would need to have her submit an RDA for the demolition. However, I said if we pass these regulations, it might qualify for an administrative approval, in which case then she wouldn't need to submit an RDA. So she wants to wait and see what we do about that. And then she'll make up her mind, I guess, at the end of the month. We did a site visit. I did a site visit with DP last week at 576 West Pelham Road. And so I wanted to share with the commission what I observed in that site visit. This is where there's been a report of some violations on this property, including filling in an area, a wetland area, and doing some other alterations. And we went out with DEP officials and some waste site cleanup officials from DEP, as well as David Haynes, who's a wetlands consultant working for the landowner, and then the landowner was there. And what we observed was a large area where there's been a lot of fill added to change the grade right next to a large bordering vegetated wetland. Unclear whether he filled in a wetland. He definitely filled in the buffer zone right up to places where we saw cattails. So again, we don't know where the wetland boundary is. My understanding is that they are currently in the process of doing some excavation in order to find the wetland boundary because it's buried. The landowner wanted to level this area in order to make it a livestock corral. So it would have been a livestock corral right next to the BVW, which is concerning in terms of runoff, because there was literally no distance between where the end of the fill is and where the water in the wetland was. So there was no space for any kind of infiltration or filtering. And then we found two areas where he built a stream crossing with a culvert and then a smaller culvert for another area. And what was concerning about that, I mean, it's a permanent culvert. It's armored with a lot of boulders, but it's a very small culvert pipe. It was only a 6-inch diameter pipe. And I shared with DP that I had a lot of concerns that it was undersized. And on the upstream side of it, there was a pond that was clearly, anthropogenic and human-made, and probably was maintaining and impounding water because the pipe is so small. So it's sort of starving off the wetland downstream. And then there was a long linear, like stormwater swale that he had dug from that wetland all the way along this access road for maybe 1,000 feet, maybe longer. So we have not heard from DEP what they're going to require. They had agreed to take up enforcement for this. So do you have any questions or comments?
What's the question, Miriam? I know we mentioned this before, but from what you saw there, do you see any, in addition to what DEP might be looking at under the Wetland Protection Act, did you see anything there that may be only applicable to potential violations of the bylaw? And are those being looked into, or are they really just focusing on Wetland Protection Act as a place to start?
Well, that's a really good question. And since we don't know what they're going to propose, it's premature. And I imagine they're not going to propose anything until they know where the wetland boundary is. The applicant seemed very willing to fix things, but he also wanted to keep his livestock being able to cross over this wetland to get to a pasture uphill. I'm not sure he's entitled to an agricultural exemption under the Wetlands Protection Act because he's not doing any commercial agriculture. It's just kind of a hobby farm. He's not selling any produce. So the alterations of BVW are jurisdictional under the Wetlands Protection Act. I don't know what DP will do around the buffer zone impact. I had a lot of concerns about the changes that were made to the buffer zone because he really changed the grade with a lot of fill. We're talking about like probably hundreds and hundreds of tons of fill. And, the proposed use could lead to point source discharge, or I guess non-point source discharge, because he wants to keep livestock really close to a wetland. So and there was no provision made for any kind of stormwater containment between the livestock area and where the wetland is. So, any stormwater runoff from the livestock area would go right into the wetland. I think that could be a real concern in terms of water contamination. But I think what I understand from a conversation I had with Donna McNichol, our town council, is that our jurisdiction is preserved, even if DP picks up enforcement. We don't want to jump the gun, I think, and get into issuing any enforcement orders because we don't have conflicting or duplicative enforcement orders about the same activity. In fact, you can't have duplicative enforcement orders over the same activity. If we were to issue an enforcement order tomorrow, DEP would have to withdraw. And if DEP, if we issued an enforcement order and DEP wanted to step in, they would require us to withdraw our enforcement order. We can't have two enforcement orders. That's sort of like double jeopardy. So does that answer your question, Scott?
Yeah, and I wasn't suggesting jumping in with enforcement. It was more of a question of investigation at this point. I know that DEP is investigating, potential violations of the Wetland Protection Act. And I guess my question was, do we feel, is there any need for any additional investigation that maybe they're not looking into because it's not jurisdictional to them, that we would need to look into just to make a determination of facts as it relates to the bylaw?
I think that's a good question. And I think the question that remains to be seen is whether we would want to know more about the alterations of the buffer zone. And whether we feel satisfied with the investigations that DEP does. And I would hope that they would share with us what they're doing and requiring. They were pretty mum with me. They didn't want to kind of, make any decisions at that site visit, and they haven't given us any information. If we want to follow up with them and ask for more information, I could reach out to them and ask for what kind of information are they asking for. It would be nice if they had CC'd us anything, but they haven't.
Yeah, I think we need to keep asking them, if a delineation is being done. We certainly want to make sure that that delineation is being done and being submitted to DEP, even if we're not issuing our own enforcement or whatever, just sort of to keep track, make sure that these things are being investigated and taken, you know. I mean, I guess I would assume DEP would keep us in a loop as they move along, but
I'll reach out and ask where things stand. And the other piece of this was there was another potential violation that was discovered in a turnaround area on this man's property. There's a bus turnaround that's used by the Shutesbury buses as well as the highway department for the snow plows to turn around. And there's been filling in a wetland and in the buffer zone in that area. And somebody's also been dumping some sort of grass clippings and leaf debris in the wetland there. And it's right on the boundary with Pelham. So part of that potential violation, if it isn't our jurisdiction, it's the Pelham Conservation Commission's. And so they're investigating that part. The question is whether we want to investigate the part that's on our side. I guess we'd need to know if DP is going to be looking at that or not.
my guess would be they're probably not. They're probably just sticking with the back part of the property where the big filling has been going on. Because to me, I know what the area you're talking about. I think that's more, you know, there's sand and dirt and things getting pushed into that just from the plows and everything else, and then there's people dumping their yard clippings and things back there that may not necessarily be that particular property.
Yeah, it's more than just the plow. It's been filled and graded. There's about 3 feet of fill there. And it's pretty recent because it's not vegetated. So I would guess it's been the last year. The landowner says he didn't do it. He said the town of Shutesbury Highway Department did it. I don't know what to say. We could inquire. I see our new news highway department superintendent is here. Do you know? Hi, Steve. Welcome. And congratulations.
Well, thank you. I can tell you that the Shutesbury Highway Department has never put any material in there, and we don't normally even go in there to grade it in the spring. Pelham will once in a while knock it down so that the tire tracks are gone, but it's somebody else that's filling it in.
Okay. Well, who knows, right? We may never be able to figure that out. Though I suppose technically it's on the landowner's land. So, you know, to some extent he might have some responsibility. I don't know. What do we want to do?
I think a site visit might be in order if we really want to do anything, look into it at all, because we need to be clear on what we're talking about.
Okay. Well, I will schedule with you guys a site visit, then we'll move on from that.
Do we want to wait till we get DEP's
Yeah,
report before we do that?
Anything about that area. If they're just saying that's not an area that they're going to be dealing with, then I think it's up to us if we want to pursue it. I think we have the green light if they're not going to be involved.
Yep.
Okay, moving on. 140 Leonard Road. So, and welcome, Beth Goodman. I see you're here. We'll get to you in a second. We're just running late. We had some technical problems, so we started our meeting late. We did a site visit. This is a landowner who has a large bordering vegetated wetland wrapping around his property, and he wants to regrade his property and put in a gravel driveway and turnaround very close to the bordering vegetated wetland. He wants to take out a large number of trees, maybe 20 trees that are in the inner buffer zone of the BVW. The reason why he wants to remove the trees is for shade reduction, but it's not near his house. So these are not hazard trees. And he wants to put in a culvert to get drainage from the road under his driveway, that he would have hopefully have the Shutesbury Highway Department install. And when we were out there, Robin was with me, we advised him, and I had a follow-up conversation with him that, he's asking for a lot of changes to this property, both in terms of vegetation removals and grading changes and stormwater changes. The turnaround is something like 10 feet from the BVW, so it's very close. And that it feels to me like this requires a notice of intent.
Yeah, sounds like it. Has he had it delineated, officially delineated?
Have it professionally delineated, and it was flagged in the field. I'm also concerned that if a new culvert, there is an old existing culvert that's collapsed, but if a new culvert is going to be constructed, he wants it in a different location. So it's not replacing the existing, it's putting a culvert in a new location. And it's all very close to the BVW, and I am concerned that perhaps there needs to be some outlet detention basin at the outfall of this culvert in order to collect sediment, some sort of BMP, before it passes on into the wetland. Because it's a steep part of the road, so it's collecting a lot of water and a lot of sediment from down Leonard Road, and it's all kind of going straight into, well, what he's proposing will have it all going straight into the BVW.
Yeah, it sounds like an NOI to me.
So he's wanting the highway department to do the construction for the culvert, and I suggested that he may want to propose the design in this NOI and just get an agreement from the highway department that they'll comply with the order of conditions rather than having to go through two separate permitting processes for this. Does that make sense?
Yeah, I mean, I would think all of that work that you were just talking about could be one notice of intent.
Right, but then there's the culvert. Or are you saying including the culvert in that?
Right, the culvert's on his property, right?
It's in the right of way.
Ah, so it's town property. I mean, you could still put it in the same notice of intent, but just have the town possibly even sign the notice of intent also.
Okay.
I mean, technically, I mean, you can do it either way. There could be a separate notice of intent simply because it's really two parcels because, two owners.
Well, the thing I'm concerned about is that with the notice of intent for the culvert, there's going to have to be some long-term maintenance for that culvert and also whatever outfall, if there's going to be a basin of some sort, a sediment basin. And so, I don't know that it makes sense for his property to be encumbered by something that he's not responsible for because, in terms of long-term maintenance, there might be some perpetual conditions for that, but I don't see that should be his responsibility. So my recommendation really would be that it be two applications.
Would the basin be on his property or in the right of way?
Basin would be in the right of way.
Yeah.
It's
So really it's two applications and one should really actually come from the town because it's their property. He can certainly come to some agreement with the town, in terms of finances or whatever, but really, yeah, any work in the right of way should come from the town.
Steve, you want to comment on this? Let me know what do you think, Steve?
Yeah. So when we talked to him, there's a culvert there now that runs under his driveway, but it's so undersized and it's totally full that the agreement we had with him was that he would purchase the culvert and we would install it, but we weren't trying to add any kind of basin. We were just going to have it run under the driveway and then run down the road further.
Well, it's, if it runs any further, it runs right into the BVW, Steve. That's the issue. And so then the culvert is basically, and the swale is just catching all the sediment right into the BVW. So I think we might want to see some sort of treatment for it.
That sounds good.
But I think that it would need to, the application for that needs to come from the highway department, not the, I mean, I don't care who, I don't think we care who buys the material. I mean, if that's an agreement between the landowner and the town, that's not really our none of our business who pays for what. But we would need the town to be willing to submit the application for the culvert design and whatever you're doing with the swale.
Okay.
Have you done I know you're new to this job. Have you ever done an NOI before? I don't want to put you on the spot. I just mean it.
No, I have not, but I'm sure that there are plenty of people who could coach me.
Yeah, and I am happy to go over it with you, Steve, and
Okay.
we can set up a time to talk on the phone. I'm happy to do that.
Sounds
Okay.
good.
All right, so I will communicate that to the owner, Mr. O'Connor. Tomorrow, I think that's all we have in terms of discussion about past site visits. Tomorrow, we have a site visit at 3:30 at the West Quabbin Woodlands Conservation Area. I'm going. Beth, you're coming?
Yeah.
Who else is coming from the commission? Anybody?
I'm
Rob?
coming.
Scott? No. Mary? No. Penny, you're coming? You got your hand raised, Penny.
I will be there
Great.
for 1 hour.
Okay, and we're meeting with Stuart from Kestrel, and I think Jeff Lacey is joining us. We're meeting at Jeff Lacey's driveway. And it's not going to rain tomorrow, so we're in good shape.
Do we get to park at Lacey's?
Yes, park at Lacey's. Okay. I think we can move on right now. We will pass on site visit scheduling. I'm going to email people about setting up some site visits because we've got a long list of site visits that we need to get caught up on. One more thing is that we received, I'm just going to note that we got an anonymous complaint about logging, forest cutting plan logging on Montague Road, which I shared with everybody, and I did reach out to the forester from DCR who said that he didn't have any concerns about the forestry plan and what was happening. So the question is, do we want to leave it at that? Do we want to ask for a site visit with the forester? Our role is really advisory when it comes to violations or reported violations. We don't have no enforcement authority for a forest cutting plan issue.
Yeah, I feel like we did our sort of, what we should do, which is reach out to the forester, state forester, and have them look into it and see if there's any problems. And if they're okay with it, then I think that's kind of the end of our role.
I agree with that.
Okay, good enough. All right, well, moving on to the next part of our agenda tonight, we want to welcome Beth Goodman. Welcome, Beth. And this is for members of the public to know that Beth has been appointed as a special counsel to do a legal review of our draft bylaw regulations. And Beth has completed that review and was able to do it very quickly and very efficiently. She and I had some conversations. We met yesterday and we talked again today. But this is our first chance for the commission as a whole to talk with Beth. And what I'd like to do is just kind of frame just very generally, what Beth, your comments are about your legal review, what the results of your legal review are, without maybe getting too much into the weeds of particular items.
Sorry.
Hi, everyone. I am delighted to be reviewing these and happy to answer questions. I did review them. I reviewed comments by two other attorneys, Mr. McGregor and Donna Brewer. And my own comments were addressed by Miriam. And then we had another meeting with Mary. I'm sorry, yeah, with Mary David and Miriam yesterday. And in general, my general comments are that I believe that the bylaw is there. Yes, it could be updated, but I think the regulations help define your jurisdiction. So yes, it would be great if your town decides to amend or adopt a new bylaw, but I'm not the only one who's read these. There are several scientists, and many, as I said, these other attorneys. And I don't believe the regulations are detrimental or too aggressive or harm your town's efforts to control wetland values. I think they are more helpful than having no regulations. And I believe that regulations provide a structure for review, and they're helpful to applicants and they're helpful to commissions. You're not the only commissions, hopefully, who will use these regulations, and they provide a basis for your review. And each situation, you know, you get a RDA or an NOI, or even you have an enforcement, and you need definitions and structure to refer to, and these I think are helpful. So yes, they are detailed and comprehensive, but I think that all together they support and improve the work of the commission. That's my sort of general statement, which I would be happy to make in your public hearing. And I did see that Miriam has proposed an agenda for you for your public hearing. And I think that's what our meeting tonight is, to sort of get ready for that public hearing. And I don't know if any of you have questions about it, but the public hearing is going to be recorded. And so if there were a challenge, someone took your town to court and said, I don't agree with the decision of the Conservation Commission, there could be reference to the testimony to be provided during your public hearing. And you have two scientists who we are proposing to have testify in the hearing. So I'm a lawyer. I read language, I read regulations, I understand the process, but I'm not a scientist. And to say, to a judge, are these regulations suitable? You would need the testimony of an expert to say, yes, this is the way we look at science. This is the way we understand when we need evidence and why we need evidence. And so for the drafting of these regulations, I proposed, and Miriam is going to talk more about the testimony that we would have your commission's experts provide tomorrow.
Thank you. Beth, let me ask you a couple of broad sort of, sky high questions. One question is, in your review of the bylaw, is it with the severability clause in mind, because we know some parts of the bylaw may be outdated, with severability and the principle of severability, is it defensible with these regulations? And do you see any evidence of us overreaching or trying to impose or expand upon our jurisdiction unlawfully or improperly, or to infringe on anybody's property rights inappropriately with these regulations?
No, I looked at those specifically. In my opinion, thinking in your head, if you had to say someone brought a challenge directly to the regulations they were adopted, someone sued and said, I don't think these regulations are valid. I think a judge would say, that these regulations are within your authority. There's nothing here that other towns haven't adopted, and they're very often tied to the state standards and regulations. And your jurisdiction is more expansive. Towns have adopted bylaws to, and this was decided long ago. Does the state statute and regulations supersede town authority, or can towns exceed the state level? And it's clear in the court decisions that towns can exceed the control and authority of the state. And so, your town has additional wetland resource areas that are not protected under the state regulations. So it's appropriate to make regulations to say how you're going to review cases under your bylaw. And I have not found, we've looked, but I haven't found anything, in my opinion, that a judge would say, wow, that's way beyond the authority in your bylaw. And we've looked carefully. I've looked, other attorneys have looked. And I believe that in addition, Mr. McGregor has said, this is aggressive, or this isn't how other towns have done it, or, he's cited the case that says that if you don't have concrete definitions, that you could be overruled and that could subject the town to suits. But on the same hand, he said, these are so detailed and technical, it's going to be hard. So I would pose to each of you commissioners, many of you have scientific training and have read these regulations. Are there any areas of concern that you, the commissioners, want to talk to me about tonight?
No. Scott?
So, that was my feeling too, You can never guarantee that you're going to win a case in court. And anybody who says, oh, I guarantee this is right and you are wrong, I would argue is not experienced in court. Each case is circumstantial and depends on the specific judge and specific details. And so I feel that these, as we know them, are appropriate. And I think your experts who helped you draft them and the scientists who looked at them think they're appropriate. So I'm prepared to attend the public hearing and, listen to the testimony of your scientists, Patrick, and listen to the explanations we are going to give about why certain things were drafted the way they were, and listen to the public comments. No one wants a draconian, endless review for things that are not necessary. But your commission has in the regulations the right to waive. You have a waiver provision in there. And so you can look at it and say, oh, well, we know in this case, you don't need to go into all the alternatives. It's fine. We're working today with Miriam on the standard that would apply for existing septic systems. Right? You need to go in, there's a new law, you have to have an additional leach field. You have to replace a leach field, and you're doing that within your 50-foot inner, I call it buffer, you call it aura. But if it's already there, we were saying, well, let's describe how your commission review would occur in those circumstances. And I think that's the kind of thing that's helpful to go and review, like what would you really do and how would you write that out? So that was something Miriam was working on today.
Scott's got his hand raised, so I know. Scott, did you want to ask some question?
Maybe just one, and thank you very much. Good to see you, and again, thank you for all your help and review and working through these draft regs. I think I know the answer to this, but I just want to ask it here to make sure. You mentioned several times talking about authorities and authorities of the commission, authorities of the town, authorities of the state. And I know some of the criticism, I think, or comments that we've received are that somehow writing the regulations themselves would somehow improperly expand authorities of the commission beyond where they actually are. And I think in particular, a good example would be like septic system review. And I'm just wondering, and it's more of a legal question, not a technical question. Could you expand a little bit on that question of authorities? In your opinion, the way these are presently drafted, I know they've been edited here. Could you speak to whether or not you feel like this is somehow improperly expanding the authorities of the commission in some way?
So what you have now is a bylaw, and you can think of it as a sort of skeleton. It says we have certain regulations. We have certain resource areas, and we will take evidence about them. And the general arrangement of wetlands regulation in Massachusetts is if you have an activity that alters a resource area, then you have to mitigate or address that, and the commission can deny your right to do that activity, or they can allow it with conditions, right? So I think that's kind of my rough understanding of wetlands protection in Massachusetts. And these regulations expand on that. And so people may see the expansion of words. They may see the detailing of how your review occurs, where you will use presumptions, or where you will allow exemptions or infer certain things or require evidence. They may see that as an expansion of authority, but your authority under the bylaw is broad. It's just not well defined. So in my mind, definition, i.e. writing out how you're going to do something, does not expand your authority. You already have authority to say this activity in this resource area, and that includes the buffer, that can be regulated. And so if someone says, well, you're writing all these regulations and it gives you more authority, I don't agree with that. Your authority is still limited by the bylaw. And if you wrote a regulation, if you did write in a regulation that you are going to do something that exceeds the bylaw, yes, that regulation part would be illegal. And that's why Miriam started with, what about severability? Okay, we thought this provision meant, this is how you're going to define a presumption. If the court didn't think that was within your terms of the bylaw, they would invalidate that provision. That doesn't mean all the regulations are invalid. So if you look at
I'm sorry to interrupt you, but so you're saying, I just want to make sure I understand what you're saying. You don't feel that the regulations are creating new jurisdiction illegally?
It cannot. I mean, well, there's two things.
Somebody could try to do that. And that was never.
If you wrote regulations that said, every time someone steps out their door, if their foot crushes a plant, they need to come to us, right? That would be illegal. That would be exceeding the authority of your bylaw. If you write regulations that say, we're going to take these resource areas, we're going to look at whether it's an alteration, this is when you come to us, this is when you don't need to come to us, then I don't see how it exceeds the authority of your bylaw. I mean, Miriam and I already spent 2 hours with Mary on the phone going over comments from Mr. McGregor, who said that he felt like some of the regulations exceeded authority. I felt like there were several errors in his comments, which can be discussed tomorrow. And one of the errors where he said you're issuing special project permits. Isn't that what he called it? SPPs. And I had flagged that for Miriam. And I said, you don't have the authority to change how you're going to issue a permit. You either issue an RDA saying you don't need a order of condition, or you issue an order of conditions, and the notice is required. You can't undo the notice requirements and issue a different kind of permit without notice. That's illegal. Permits require notice. So I said, what you can do is allow administrative review. You can not issue a permit, but tell someone, we'll look at this and decide whether you need to have a permit. That you can do. You can review something, you know, all the time. People in many towns, you call the conservation agent, you come over and you say, hey, can you look at these trees I want to cut? I want to know if you think they're in a wetland. Do you think I should file? And the Conservation Commission agent can say, oh, I don't know, looks like it could be wet, you better file an RDA. Or he or she could say, you know, clearly this pond you want to fill in is going to be an impact on a resource area. You need to come in with an NOI. So that kind of review goes on all the time. And to put in your regulations that we're going to do administrative review, I don't think it's illegal. You're not issuing a permit without notice. You're just giving people advice on whether they need it to come in. And they can still file an RDA or an NOI, regardless of what your review is. They have that right. And neighbors can still file an RDA, regardless of your administrative review. But giving a procedure that says, we're going to look at it and talk to you about it. A lot of towns have that with zoning permits. You may have heard of that too. It says, you know, come in, get an appointment, sit down with our zoning agent, and we'll go over how our process works here. That's what I think these regulations have. So that was one area where I don't think you're doing anything illegal. I don't think you're issuing a special permit or a simple permit or whatever you called it. And we can discuss that in the public hearing. But if you have specifically questions about the septic system, I don't know if you've seen the revisions that occurred tonight at 6 o'clock.
Well, I was going to suggest, Beth, and I want to make sure, Scott, your questions, before we move to the next topic, Scott, did you feel like you got an answer?
Yes, thank you.
Okay, I think generally I don't think it's illegal, but specifically the kind of edits that we've tried to address are not expansions, but rather more detailed areas of when review would occur and under what circumstances you would presume something.
I'd like to say I found it really helpful. Beth, with Beth's guidance, we simplified some sections, including the section where we had an alternatives analysis. We're not calling it an alternatives analysis because Beth said, you know, it's a little confusing because the riverfront redevelopment regulations under the Wetlands Protection Act also call something an alternatives analysis, and we don't want people getting this confused with that. So she was talking about a different alternative language where we just talked about alternative options, and we really simplified that section, which we have done. But I would like to maybe, while we have you here, Beth, and I would like to pull it up on screen share, a couple of sections of the regulations, and maybe we could talk about what changes you're recommending. Is that okay with everybody?
Of course.
So the one you were just talking about had to do with the septic. Can everybody see the document?
Yes.
Yep.
So let me get to Title 5. All right. And Beth, you saw the language that I tweaked on the, so how did that look to you? Here it is.
So the 11.1 is just a preamble,
Yep.
which means we're describing what is true. And then in 11.2 presumptions, you're saying that if you construct a subsurface, a septic system, really, in compliance with Title V, it's going to be presumed to also protect wetlands values, which means it doesn't alter protected resource areas, if the system is located outside of resource area. So it's outside of resource area, you know, it's unlikely to have a wetlands impact. And remember, we talked about the basic structure is if you do an activity that alters a resource area, then you need to get a permit. So in 11.2.1, you're saying it's outside the resource areas, we're gonna presume it's fine. And it's, meeting Title V. And then 11.2.2 says, if it doesn't meet Title V or Board of Health, then we're gonna presume it's gonna have a bad effect on wetlands. And then 11.3 gives performance standards. So this is a perfect example of what we were talking about. You have a bylaw that just says, don't alter resource areas. What does that mean? How do you define that? And here you're saying that if you want a new system or expanding an existing system, and we looked specifically at the state regulations to address this issue. If you need a new system or expanding existing system or renovating a system in the outer 50 feet, and you get Board of Health approval, we will presume that the design meets the Title V effluent standards. If you want to construct a new system, expand an existing system, or alter a system within the inner 50 feet, you're going to presume the design meets the effluent requirements and only review construction impacts. But in any case, this presumption can be overcome by credible evidence that the system does not protect the values. And that is really a redrafting of the state regulations. They have that same presumption that it is presumed to meet, if you got a Board of Health approval, it's presumed to meet requirements, but it could be overcome. We think that defines for applicants, the role of the commission. So I don't see anything illegal in this. I don't think if you took this to a judge, he would say, you've well exceeded your authority. You don't have the right to look at septic systems, even if they impact wetlands. I don't think that will happen. I just don't see that. I'm just one person, but so that's how that's an issue, that's one of the issues that we looked at.
And
there
Beth,
are many. It's difficult.
let me just jump in. Is this language okay the way I worded it? Because we were doing this in a
We were
hurry.
doing it on the fly. Yeah. I'll look at it again, Miriam, before tomorrow. I think it's better for me to just, read it very carefully in the quiet. But yes, it seems to be the presumptions and the overcoming of them seem to be what we discussed.
So let me ask you another question, because there was some concern that was raised about, well, there were a few things we talked about. One thing here had changed. We were talking about vernal pools, and we wanted to make sure people understood that we were not proposing to regulate vernal pools in previously landscaped areas. And so we kind of added this language at Beth's recommendation to highlight the fact that if there's an area that looks like it has vernal pool characteristics, but it's in a previously developed area, we're going to presume, can you hold on one second? We're going to presume that area, because it's so degraded, is not going to have high values for the wildlife benefits of vernal pools. But let me get down to page 31. So I'm scrolling a little fast because I have it highlighted. We're talking about auras and the effort we made in these regulations to protect the inner 50 feet. And there was a comment that we were going to sort of over time remove all structures within the 100-foot buffer zone of resource areas, I think was the comment. And so Beth and I took a good look at these performance standards to say, well, is that really what these performance standards are saying? And what we say here is that pre-existing structures are going to be exempt from the inner 50-foot no disturb zone that we're discussing in Article 1. But there was this language here in 6.44 where it said and I just added this red. It originally said previously disturbed or previously developed inner 50 feet of aura shall be restored to a naturally vegetated state to the greatest extent practicable. And I thought, well, maybe somebody's going to interpret this as that we're going to go around town and just find everybody's properties who have buffer zone in it and say, and issue enforcement orders and order everybody to restore the inner 50 feet. I mean, I don't, that was certainly not how I read this, and certainly was not our intent. So I wondered if, out of an abundance of caution to make sure that people understand that is not our intent, adding this red language would make sense, Beth. When an applicant proposes a project within the aura and we're reviewing it, then we would look to see how they can enhance the inner 50 feet to the greatest extent possible.
Yes, and I want to see, I'm trying to page down in your, I have the regulations. Page 31. I just want to see your other conditions again in the whole context of, oh my, 6.
Again, it's really about mitigation because we're treating the buffer zone as a protected resource area. And when an applicant is proposing alterations to the buffer zone or the aura, we're looking for some environmental enhancements to mitigate those permitted alterations. So we're not, it doesn't mean we're going to order somebody to tear down their house or their garage. Far be it, we're exempting, pre-existing structures. But if somebody said, I want to tear down my house and my house is 1,000 square feet, I want to build a 5,000 square foot house. Instead, we might say, okay, well, we might allow the 5,000 square foot house, but you're going to have to kind of pitch it farther away from the wetland as much as possible.
So, you might require a wider undisturbed buffer in the aura. You're not going to go beyond the aura.
Right.
So you would say wider undisturbed buffer in the aura.
Yeah, I think it was the word buffer is perhaps confusing. We could say a wider undisturbed vegetated
area in the aura.
Area within the,
yeah.
I think that is a better word, because somebody might read that and say, oh my God, they're going to expand it.
Yeah, they're going to go beyond your jurisdiction. That's illegal, right?
Or they're going to go 1,000, which is not a good, yes, I think that's a good fix.
I think that whole area that you had highlighted green, you might want to just change the language to something like, if impact to the inner 50 feet of the aura is proposed as part of a project, then the Conservation Commission may propose restoration. Because nowhere in there you're just sort of saying when an applicant proposes a project. So it could start that way. When an applicant proposes a project within the aura, and impact is involved, impact to the aura is involved, the commission.
You don't need to say proposes a project within the aura and impact is involved. You can just say when an applicant proposes a project with impact to an aura, right?
Sure, with impact to the aura.
Yes, I'm right. Go ahead.
The commission may.
Yeah, you don't need previously disturbed or previously developed, right?
Okay.
Just if you got impact to the aura,
then
the commission may propose mitigation involving.
It may require. It's not really propose. We don't propose. We would require.
The commission may require
mitigation or
involving restoration of restoration. Some of the language you have there.
Yeah, involving restoration, including but not limited to.
Restoration, including but not limited to. And then
you can just say wider undisturbed vegetative area and new structures setback greater than 50 feet. And you don't need to require there because you've said require above.
You guys are awesome.
Do you need, yeah, you don't need, do you need to talk about the 15% on highly erodible soils or hydric
No, I don't
conditions?
think so. I don't think we need to.
Okay, because that's good. I like that. I like sort of more general authority, but like, so you say, when we could simplify, but still give the idea.
All right. Okay. So I think that kind of addresses that. And are we gonna, we're okay with the rest of this, I think.
Mhm.
Except that this is the wrong font. All right. Good. Okay, so are there, I'm going to stop sharing because that was really the only thing. What I do want to say for the commission is that this draft, I'm going to clean it up and distribute it to everybody again. And I want to put it up on our website so that the public has access to it. So I'm going to do that after we meet tonight. And there have been some other edits that have been made in the last couple of days with Beth's recommendations. And I don't have the list in front of me of all of them, but there was a questionable passage about endangered species that Mr. McGregor raised concerns about, and we have deleted that.
Deferring, if I could interrupt, deferring the tradition in the shared jurisdiction over habitat that's endangered species habitat and also wetland resource area is that natural heritage statute has separate statute, and we just defer to them. They have authority that supersedes and trumps anything.
Yes,
they are the, I don't want to make religious terms, but head of that area. They're the
and we took out
that's
some
right.
We took out some references to the Wetlands Protection Act that made it sound a little confusing, like perhaps these regulations were actually administering the Wetlands Protection Act. So we took those out because that was not the intention. And I'm trying to remember what else.
We talked about the special the administrative review, which is not a permit. That was a change. And then there was a focus again on the theory that the commission was requiring donations of land or easements, environmental easements. And I had already reviewed the regulations and determined that, and Miriam had already made that edit that says it's, you would only accept voluntary donations of restrictions. So somebody could come in and say, I want to build this project and I'm going to give you this and look at all these benefits. Will you accept it?
Yes.
And you cannot, it's clear, and Mr. McGregor agrees with me on this, you cannot require a donation of land or a donation of an easement. That's an illegal taking.
Yes.
And that's the kind of thing that, yes, it's great to have all these people reviewing and commenting on the regulations so that you don't inadvertently make a mistake and require something that's illegal. Okay. But that's why I'm asking each of you who are experienced commissioners and who have, understanding of wetland science, did you see anything else that gave you concern? So, we're trying not to be expanding beyond the jurisdiction of the bylaw and addressing all the comments.
Yeah, I mean, I think I agree that I've always thought we're not going beyond the bylaw, but I think what we're running into with residents and other people is that compared to our old regulations, we're just getting much more specific about what we're going to do, which is great because it will guide this commission, it will guide future commissions, which is wonderful. But I think for a lot of people, a lot of residents, they've never seen, the fact that we could look at septic systems, the fact that we could have a 50-foot, even though lots of other towns across Massachusetts do these things, the residents of Shutesbury have never seen that before. It wasn't in our old regulations. It wasn't the way previous conservation commissions here in Shutesbury made decisions. So they do see it as a change and as sort of an expansion, even though it's certainly not an expansion, I agree, over the bylaw at all, which is what Mr. McGregor is saying, and I don't agree with that at all, but I see where some residents are looking at it and going, whoa, you know, just because they had never realized.
No, they didn't know what the bylaw actually allowed you to do.
Yeah, because our other regulations were so, you know, kind of vague and short and didn't have all the specifics that these do, which is it's good that we have them, but I can see where people have gotten concerned. So I think that's what we're running into.
One of the things that Beth and I were talking about, and I think it really is important and bears repetition, is that regulations, and in my experience, you know, what I've learned about environmental law, often have declarative statements like this isn't okay, or you shouldn't do this, or you can't do that. There's always discretion in any given situation where we evaluate how to apply those to a given situation. And that's why there are regulatory bodies, because if it was all prejudged and black and white and clear, then people wouldn't need anyone to review things, but it isn't. There's always, but the point of these regulations is that we have waiver provisions, so that we're always going to look at these statements like, you know, thou shalt not, or you shouldn't, or we don't want you to do X, Y, and Z. And we're going to be balancing that against the landowner's application, where they're going to explain to us why they need to do X, Y, and Z. And applicants can explain that to us, and then we can grant waivers, and we do grant waivers. Currently, we're just making it more clear how we're going to do that. What Beth said is, you know, compliance is not a ban, right? That was,
I think I said specifically regulatory, you know, by definition, regulations are not a ban.
That's right.
They're an explanation of what your review would entail and when you need to come. Look, people should not be building in wetlands, right? They should not be expanding or building in wetlands. And they only should do it if they have to. And then if they have to, they should mitigate. They should have a scientist say, I did this, I'm, you know, just having a construction impact, and I'm going to put it back and it's all going to be fine. Or I have to have a permanent impact. It's the only place I can build. And so I'll mitigate. There are ways to address the issues, but you have a mission. You're a conservation commission. Your mission is to protect wetland resource areas. And you need to fulfill your mission. And people may say, oh my God, that's your mission. Well, the answer is yes, that's your mission. I don't think a judge is going to say, oh my God, you've exceeded your mission. But if he does, it's not because you did it wrong. You are doing it right.
Thank you. That's really helpful. Any more questions for Beth? Well, we're going to have more of a discussion on Monday night at 7 p.m. And I would like to propose an agenda and have us agree on it. And I put together a draft agenda. Let me see if I can pull it out. And I would like us just to make sure we're in agreement about it. Hang on, my computer is doing things I don't like it to do.
While she's calling that up, if I can just give my little lecture, I believe that you should listen to comments. So if you know your scientists are going to testify, it's very important to have a legislative history, so that if anyone does raise a challenge, there's an understanding of why something was written, like why do we have a standard for hydric soils? But also you all should listen. And if it raises any doubts or concerns with you, or you feel that it's too confusing for you to understand, then I think after the public hearing, you can meet again like this and have a board discussion about whether the regulations meet your criteria. Every board can change the regulations too. These are not written in stone. They're not concrete.
If we find something is unworkable, hopefully we won't, and we've reviewed things to prevent that, but we can have we can have a public hearing and then just revise them.
Yes.
So the agenda that I'm proposing, that I would do an introduction, introduce who everybody is, and maybe a brief summary of how we got here, just what the time, what the chronology has been. And then reminding the public about the policy that we have about making public comments and public hearings. We have a time limit and we have some other things that I'll just reread that we've approved for other public hearings. Then I would invite Patrick Garner to respond to these particular items from Attorney McGregor's legal review, because Beth felt that these were the ones where scientific expertise was needed to comment on these how these regulations address those issues. So I'm just got the numbers there. I'm not going to read through them right now. And then I was going to make a response on behalf of the commission. Beth and I went through and prepared some responses, mostly kind of clarifying comments or explaining how we've already made edits in response to those, or, based on
Procedural review,
or our special counsel has advised us that, whatever. And I would have Beth chime in, generously whenever you felt at that point, if I missed that, because I would sort of feel like, if I'm presenting those comments, in some ways I'm presenting Beth's comments for her, and then Beth would be, we would invite Beth to make any other comments that we might have missed. And then we would open it up for the public to ask questions and make comments. And if time was permitting, we could have some give and take and answer questions. Hopefully we could answer questions. If we can't, if there isn't enough time, then we could write those questions down and put written responses up on our website in response to them or something like that.
Seems good to me. I guess my one comment is just looking at it, thinking of how many residents sort of were requesting, going specifically through sections of the regulations. And I know we've talked about this, where we just feel like that's just seems like an impossible thing to do in a public hearing. But I just thought of it again, that they asked for that, and
Let me a proposal, Beth, as an alternative to that. I think that's an impossible ask, because we could get bogged down for years going through it. And what would be our standard for when we would be satisfied? I'd like to propose to the commission that if we do approve some version of these regulations, that perhaps we have some educational sessions afterwards where people could come and we could discuss the regulations and answer questions at that stage.
And I'm hoping that the new draft answers a lot of those questions that the public had, which, and the biggest part was simplifying it, shortening it, and making things clearer. I do think we've tried really hard to do that. So I'm hoping that meets some of what the public has a better understanding of.
Mm-hmm. Yes. Well, and so I think that it's another, I don't know, maybe there's another way to do this. When people have asked questions, I've tried to update our frequently asked question document that we have on our website. So, that has been updated every month or so with new content based on the kind of written emails that we've received or comments that people have raised in meetings. So been trying to be responsive to that.
Miriam, I haven't checked. Does your website say, contact us, here's how you send an email, anything like that?
Oh, yes. Yes, it does.
So people could in advance of this hearing also send written have you gotten written email comments?
Beth, we sent out, well, we have on our website, and then a few weeks ago, we sent a town-wide email. There's a email distribution that the town operates for town residents, and we sent out a notice inviting comments. So we've told people that they can give us written comments by email or some other, they don't have to do email, or they can come to the meeting, or, whatever other modality people want. They could send us something by snail mail. We've gotten some comments, some of them, I would say in general, almost all of the comments have been very general. They haven't been specific. They haven't been saying, I'm worried about X, Y, or Z. It's been more like, I don't like these regulations, or I love these regulations, or I'm afraid of these regulations. So not very specific. There have been a few specific ones, and over time, when we've gotten specific ones, we have edited this document to take into account that feedback. So we've gone through many iterations of revisions and incorporated comments. I couldn't possibly give you a document with track changes with all the changes, because
Right. I know it's changed a lot.
well, it's been going on for months. There's been many, many versions. So I think that the accumulation is been all incorporated. I don't think that we've ignored any specific content that somebody raised. There was, yeah.
I think you can listen, as I said, listen carefully. We can all listen during the public comment period. And it's also possible to craft something like Q&A or frequently asked questions. As you said, where you say, well, people have asked, why are you regulating septic systems? If they're approved by the Board of Health, might be a question. And your answer would be, we regulate septic systems that are closer than 50 feet to a resource area in the aura, and we regulate septic systems that haven't been approved by the Board of Health, and we regulate septic systems that might have an impact on, an adverse, an impact on cause an alteration of wetland resource areas.
Yeah.
Something like that. I mean, you can craft an answer.
Yeah,
we regulate these, C-section this, that's why.
Yeah, we have a document like that, Beth, is what I was saying, and we've added to it over time. So when questions come in, if there were answerable questions, then I've added to that document. So it's been growing. It keeps getting longer, but it's on our website. It's and I can continue. I would continue even after this. I feel an opportunity here for education, and I appreciate when people do reach out, because they're caring about it and they're curious and they want to know. And I think that's wonderful that, people are wanting to be engaged around wetlands protection and learning about wetlands.
So the public hearing is Monday night?
Yes, it's 7 o'clock on Zoom.
Just wanted that out there in this meeting.
Yes.
So all can remember to attend.
All right, I think we should wrap up and let you go, because we still have a little bit of unfinished business that we need to take care of on our own.
Yeah, great. Again, if you have questions, you can email Miriam for my review.
Okay, and very good. Thank you so much.
Thank you. I'm very happy to participate in this project. I think it's a good project.
Thank you.
And I think it's helpful. And I thank you for letting me be part of it.
Thank you.
Thank you.
Okay.
All right. Good. Okay.
Good night.
Good night. So I'm just thinking about which of the RDAs we did not finish up. Beth, do you want to take over the part for mine, since we didn't do that?
Yeah, I think yours might be one of the only one that we didn't finish up. Yeah, I don't know if I can bring up the documents. I had them, but I don't anymore seem to have them. But again, is the commission comfortable with it's a standard order. The order of conditions that we put together a draft of is basically the standard, not order of conditions, but just conditions for the determination with just the addition of Miriam sending photos of the erosion control once it's up, and then also photos when the project is complete. But besides that, it's just our standard conditions. If everybody's all right with that, and it's
Yeah.
so this
All
would
right
be
with
a,
it.
yeah, this would be a determination under the Wetlands Protection Act, determining a negative determination 3 because it's buffer zone. And then it would be similar under our bylaw. It's buffer zone, or it's aura, and it would be a number 3. I think those are the only boxes that were checked off. So, yeah, if people are okay with all of that without actually seeing the documents and are okay with electronic signatures, then we're good, and we can have a motion to issue the determination of applicability with the special conditions under both the Wetlands Protection Act and the Shutesbury bylaw.
So moved.
Second,
Second,
all right. Harrington,
aye.
David,
Aye.
Khan,
Aye.
and Wilson, aye,
Aye.
and Stefan abstains.
Okay, so Beth, if you send me the documents, I will get them to Carrie. And we don't need to do certified mail to me. I'll arrange to get them hand delivered to me. I will deliver them to the town to deliver to me or something. I don't know how that works. It's a little ridiculous. But I will sign an acknowledgement that I've received them. How's that? And I will load it up into DP, EDEP, to make it a little easier. For the 2 DOAs that we issued earlier tonight, I just remembered that I need the commission's permission to sign digitally. Yes?
David, aye.
I'm good.
Aye.
All right, I think just consenting is fine. And I think we're done for tonight. Are we done?
Yay. Motion to adjourn.
Second.
See everybody on Monday.
Oh, wait, gotta do a roll
Oh,
call.
boy.
David, aye.
Fun, right?
Defont. David, I, Defont, Harrington,
Aye.
Khan.
Aye.
So I will see some of you tomorrow at 3:30.
All right. Yeah, that too.
Enjoy.
Get that. All right, night, everybody. Bye-bye.